Well, hello and welcome back to the #1 real estate study guide channel out there. Welcome back, my multi-millionaires. And today we got mandated disclosure. We got mandated disclosures in real estate practice. So let's get straight to it. All right, #1. Where would one file a complaint based on the Rumford Act? The NAACP, the OEO, the ECOA, Civil Rights Department is the ECOA. Ooh, the Civil Rights Department. A complaint based on the Rumford Act can be filed with the Civil Rights Department. #2. Statements known to be untrue or the time they are made are called negligent misrepresentation, innocent misrepresentation, actual fraud, fraudulent misrepresentation. Let's see. Statements not known. It might be innocent misrepresentation. Yes. Innocent misrepresentation are statements not known to be untrue at the time they are made. An agent is usually not liable, although the buyer or seller could cancel a contract over it. Question #3. For street improvements, lots are assessed according to market value, square footage, performance, front foot. Let's say square footage. Front foot. According to county regulations, assessments for street improvements are based upon the front foot dimensions of the lot. If an investigation determines a violation of the Rumford Act, an owner can be made to do all of the following except: the owner must pay up to $1,000 in damages. The owner must convey title to the victim. The complaint is entitled to the next available unit. The owner must complete the rent or sale. Let's go with A. It's B. The owner must pay damages, offer the next available unit, or complete the sale. So the seller must convey title. All right, #5. Broker inspection requirements are limited to what properties? Multifamily housing, 1 to 4 dwelling units, commercial property, industrial property. 1 to 4 dwelling units. Senate Bill 453 includes the requirement for brokers to inspect property. This rule applies to 1 to 4 family dwelling units. Question #6. How long must a broker keep transaction files? 5 years. It's 3 years. Boy, I thought I knew it. 3 years. Real estate law requires records to be kept for a period of 3 years. Okay, #7. Who enforces anti-discrimination and assures housing accommodations regardless of race, creed, or color? State Department of Housing, Civil Rights Department, Real Estate Commissioner, State Department of Labor. State Department of Housing. Ooh, Civil Rights Department. All right, question rationale. The California Fair Employment and Housing Act, formerly the Rumford Act, prohibits discrimination in the sale, rental, or financing of particularly all types of housing. Violations are reported to the State Civil Rights Department. Question #8. When a person passes the state license exam, how long do they have to apply for a license? 6 months, I believe. 1 year. It's 1 year. You have 1 year after you pass to apply to get your license. When a person passes the exam, they have 1 year to apply for a license. Sorry, guys. It's kind of hot up in here. So let's get these last 2 questions out of the way. When a buyer asks an agent which form of co-ownership they and their spouse should take, the agent should recommend a tenancy in common, recommend tenancy by the attorney, recommend joint and survivorship since it avoids probate, not make a recommendation but advise seeking legal advice. I believe it's D. Yeah. The sales agent should not make any recommendations because they would be committing the unauthorized practice of law. They should have them seek legal advice. Which of the following would have priority? An assessment lien for street improvement recorded April 5th, 2022. A homestead recorded April 1st, 2022. An unrecorded mechanics lien, first deed of trust. I think it might be the homestead. Oh, it was the assessment lien. Government liens, assessment, property taxes, etc. have priority over all other liens. All right, you guys. And since I love studying with you guys so much, I'll give you one more. Damn, had to be hella long. Broker B, who represents a seller under an exclusive listing agreement, receives 2 offers for the seller's property at the same time. One from an agent in their office and one from a broker of a cooperating brokerage. What should the listing broker do? Submit the offer from his agent first and let the seller decide on... Nope, wrong. Submit the higher offer first. If it is not acceptable, look at the other one. Submit both offers at the same time, allowing the seller to make a decision after looking at all the facts. Just this one. Let's go with C. And the last option was submit the offer from the co-op agent first and let the seller decide on it before looking at the other offer. Yes, C. There's no written rule about the order to present offers in most states. However, the seller has the right to know all the facts and look at all the offers before reaching a decision. All right, you guys, thank you for studying with me today. Hopefully you get some valuable information out of this one and rewatch it 3 times, reread it 3 times. Subscribe, like, and comment. Let me know when you guys pass your test on the first try.